Good morning, everybody. Gary here, Fathers for Justice. It is the 14th of June, 2021. You guys are going to have to bear with me with my shiny, bright glasses reflecting because I need to do a lot of reading with you guys this morning. I'd just like to point this. I'm sort of like plowing through and trying to do a subject, and I'm reading through the Constitution and the Children's Act and all of those kind of good things. And I sit here stunned and amazed, and I'm saying, but my God, we have all the laws. But because of the child abusing divorce industry, nothing is applied. And of course, you guys are not getting this information from your grossly overpaid lawyers, etc., etc., etc. And yeah, let me not go into membership fees and stuff like that. Anyway, we are going to be discussing today a children's lawyer, a lawyer appointed, a court-appointed lawyer for children. And I have always wondered why your lawyers don't advise you to request one. The way I read the Act, and I stand under correction, so I'm going to give you all the acts and the chapters and verses and stuff like that so you guys can go and do your own investigation. They're not going to appoint a lawyer for every single matter engaging in a child, regarding a child. But most definitely in where the child is endangered, high conflict, bad situation for the child. And my take on this, my view on this, specifically around removal of children to another town, country, or province, absolutely you should be having a lawyer appointed at state expense, or it says here something along the lines of at the party that is at one or both of the parties' costs. And I'm saying in this instance, the parent that absconds to another town, province, or country should be the first port of call to be paying for a lawyer to represent the children's best interests. Okay, the other area, and I'm sure none of you will be surprised, is obviously those with regards to parental alienation syndrome. And I'm saying absolutely, the state should not be paying for it. The alienating parent and his or her lawyers, advocates, psychologists, etc., etc., should be the ones that are billed. And I'm saying immediate attachment or attachment orders should be instituted as a matter of course. So go in there. You are the alienating parent. Your lawyers and your psychologists and your advocates have aided and abetted you in abusing your children. And I'm saying that what you should be arguing is that the lawyers, the psychologists, the social welfare workers, along with the alienating parent, should be automatically billed for the lawyer and any other legal or psychological assistance that the child may need during the process. As far as I'm concerned, the state should be obliged under current circumstances to pay 50% of it, because I'm saying the state doesn't recognize parental alienation syndrome as child abuse. So until such time as the state recognizes parental alienation syndrome as child abuse, they should be equally liable. Okay, so we are looking at a lawyer for the child. The definition that comes on old Google says to us the first definition is Curator ad litem. And Curator ad litem is a legal representative in Scots law and Roman Dutch law, appointed by a court to represent during legal proceedings the best interests of a person who lacks the mental capacity to make decisions for themselves. So that is curator ad litem. And then we have guardian ad litem. Give me a second. And a guardian ad litem, or GAL is the acronym, is a person the court appoints to investigate what solutions would be in the best interests of the child. Okay. So the Constitution. So let's go and look at the Constitution, and if I can just pull that up quickly, I will read it to you. So Section 28 of Section 28 of the Constitution of the Republic of South Africa. It's Section 28, and it reads the children. So there are various things here, and I will post it up for you guys so that you guys can have it as part of in this YouTube video. And it says here, it says, have a legal practitioner assigned to the child by the state and at state expense in civil proceedings affecting the child if substantial injustice would arise otherwise or otherwise result. Okay, so that is Section 28 of the Children's Act. Have a legal practitioner assigned to the child by the state and at state expense in civil proceedings affecting the child if substantial injustice would otherwise result. Okay. Then we go to Section 20. Hold on, I'll tell you now. It's Section 29. I just want to be correct. Damn it. Sorry, give me a second, guys. Let me just get there. Sorry for the delay, guys. Just give me a second. Okay, court proceedings. 29.6a and b. The court may, subject to Section 55, and I will give you that now, appoint a legal practitioner to represent the child at the court proceedings, and Section B, order the parties to the proceedings or any one of them or the state if substantial injustice would otherwise result to pay the costs of such representative. So that's, I go back to the, so either at court expense and or another individual to pay for such representative. And I'm saying what should happen is that you should demand that the child, a lawyer or guardian or a curator ad litem should be appointed for the child. At currently under, I'm saying 50% for the state and the rest for the alienator and his or her lawyers, advocates, and psychologists should be billed for the other portion. And I'm saying I want the top notch, the best, the most expensive lawyer in South Africa to be representing that child, and advocate and psychologist. 29.7. If it appears to a court in the course of the proceedings before it that a child involved in or affected by those proceedings is in need of care and protection, the court must order that the question whether the child is in need of care and protection be referred to a designated social worker for investigation in terms of Section 155.2. So that's 29.6a and b are the most important in this matter, in this instance, as far as I'm concerned. Section 55 of the new Children's Act of 2005 reads, legal representation of children. 55.1. Where a child involved in a matter before the Children's Court is not represented by a legal representative and the court is of the opinion that it would be in the best interests of the child to have legal representation, the court must refer the matter to the Legal Aid Board referred to in Section 2 of the Legal Aid Act 1969, Act 22 of 1969. Section 55.2, the board must deal with a matter referred to in subsection 1 in accordance with Section 3B of the Act, read with the changes required by context. Okay, so we need to go to the Legal Aids Act of 1969, and I will update that at a later stage. The point I'm making is, guys, specifically in high conflict cases, parental alienation and removal of child to another town, province, or country, I'm saying the alienator, the remover, the person that has done the damage must automatically be penalized. This should be one of the very first penalizations of the individual that is engaging in the abuse, the emotional and psychological abuse of the child and his or her legal and psychological team. And I'm not interested in hearing the Judas response. I was acting under the instruction of my client from the other side. I do not go to a brain surgeon and tell him how to do the brain surgery. I do not go to a mechanic or electrician and tell the mechanic how to fix the car and how to come and do the lights and the electrical plugs in my house or my factory or business. I go to the brain surgeon or the mechanic or the electrician because I don't know how to do it myself. I am referring to an authority. Okay, so the Judas, the deceitful, the dishonest response by mommy or daddy's lawyer, the alienating parents, lawyers or psychologists, that they were acting under your instruction. No, please go to hell, you piece of garbage, you piece of excrement. This is not a get out of jail thing. You should see what your client is doing. You are only engaging your client because you know you can make blood money off the suffering of the children. You are a despicable, deceitful, dishonest human being. Okay. Ladies and gentlemen, I once again want to point out, if you start reading the acts and the Constitution and the court proceedings and the Domestic Violence Act and the Legal Aid Act and all of those kind of good things, what frustrates the hell out of me is these laws are there. But yet we have deceitful, dishonest, lacking in integrity, pieces of excrement, lawyers and advocates and psychologists that choose to ignore or obfuscate the law to their own financial gain at the emotional and psychological expense of our children. Okay. The only way we're going to do this is if we change the law fundamentally, and that is only going to happen if the government is forced into changing the act so that the starting point, the rules of engagement, the starting line are specifically defined. And until that happens, this nonsense is going to continue. Ad infinitum. Join the class action suit, pay your membership fee. Please go like, share, and subscribe this video, our YouTube channel, Facebook, LinkedIn, and Google. If you need assistance, direct assistance, or a consultation, or mediation, if you need life skills training, if you need parental training, and so on and so forth, info@f4j.co.za. Have a fantastic day further. Love to you all.